What's going to happen when the court comes down here 15 days from now. 15 days from now we'll be up on the stage. Justices will be up here. We'll actually have heard a case. I can't tell you too much about the case, except that it's a murder case. And the issues are going to involve sufficiency of the evidence and then some legal procedural issues. And that's, I mean, all that can be kind of boring and dull, but that's what the legal system is about, is to make sure that everybody has a fair trial. And is that we have a contract in our country that basically guarantees that right. Anybody know what that contract is? Well, part of it. Yeah, now let's see, we just celebrated the anniversary of the Constitution on September 17th. In fact, I was over at Metropolitan State University, and I was done with the presentation. I actually led the groups in singing Happy Birthday to the U.S. Constitution. I asked, it was a little corny, yeah it was, but I wanted them to be left with the ideas that what we were celebrating is the birthday of the Constitution. And what you need to understand about the Constitution, I mean, do you do world history here?
Yes.
You talk about John Locke? Does anybody remember John Locke? You know, some dead white guy that your teacher was kind of boringly telling you about? Well, John Locke came up with this idea of a social contract. And he actually built on something from a guy who was about 40 years earlier, Thomas Hobbes. The idea, the radical, I need a volunteer. Can somebody come up? Okay, come on up.
There.
What is your name? Caitlin. Her Royal Highness Queen Caitlin. She is your sovereign. She is your queen. About 200 years ago, she had an ancestor, who would have been a male ancestor, who put together a group of knights, and they overthrew the powers that be, and is that established her family in the royal line, and they established a hereditary monarchy who were named by God to be better than everybody else. Her father did not have any male children, and so that is how she became queen. She is all-powerful. She has absolute power over all of you. Life and death, whether you could be a lord or lady of the realm, whether you get sent to the tower, whether you could be summarily executed. That's a lot of power, isn't it? Yeah. Is everybody comfortable with Her Highness Queen Caitlin having all that power?
No.
No? What? No, why are you worried about Caitlin? I don't know. Why are you? She has too much power over us. Well, wait a second. You want order in your lives. You want stability. Oh. He's dangerous. Mr. Hagley, could you get him out of the room? He's a threat. Would you take him out of the room? No, I want you to escort him out of the room. Take him to the tower. Come on, get out of here. I mean, you are a threat to the... I'm serious. You talk about freedom. You don't believe me, do you? Mr. Hagley, I want you to come over and take him out of this room. Because... is that that's what happens. I mean, this guy mentioned the word freedom. He came up with this terribly radical notion that he had some individual rights himself. That's scary for you, Caitlin, isn't it? Because he gets too many people going that same way, you could be overthrown, right? Yeah, okay. Well, this is what happened with John Locke. And this gentleman here has to be very grateful to John Locke because we now allow him back in the room. Because John Locke came up with the radical notion that life, liberty, and property, we define it as pursuit of happiness, rests with every individual. So Caitlin, what happened during the American Revolution, and you are the personification of King he won. He and his cohorts won after a long and protracted battle. If you read 1776, you realize that George Washington understood something about Revolutionary War. He didn't have to win. He just couldn't lose. And that's what happened for the most part up until the end of the Revolutionary War. Is the rebels understood that they didn't have to win. They just couldn't lose. And they wore down the other side. And it's a massive, they beat the best army in the world at that time. And what drove them was a principle of freedom. You know, ever heard of the song Me and Bobby McGee? Yeah, it's Fred Foster and, Fred Freeman. There's a Foster Freeman, Chris Christopherson. Anyway, it's that, I think it's Fred Freeman. There's a worker down on the floor right below him was named Bobby McGee. And there's a rumor that they were sweet on each other. And it's that somebody came up and he said, yeah, me and Bobby McGee. And then he just clicked. But anyway, there's a line in that song, Me and Bobby McGee, that says, freedom is just another word for nothing left to lose. And boy, did they get it wrong. They really got it wrong. Because freedom is everything to lose. Yeah, I know, is it? And it's a great lyric because it can either be, Bobby McGee can either be male or female. So when Janis Joplin does it, you know, it's or when Chris Christopherson does it, then it's, I think it's Joan Baez who was seen back then. But anyway, that's ancient history for your folks. The idea, though, is that life, liberty, and property rest with each of you. And that was the thing that was very critical to this contract that we call the Constitution. And there's a couple of things that you need to know that were going on when that Constitution was passed or ratified. One is that the people who were drafting that document were worried about not only Her Majesty, okay, but they're also worried about all of you too. They're worried about how all of you might exercise your power with respect to fellow citizens. And they also knew that some of you would come into positions of leadership in this republic, and they were worried about how you would perform in that role. And so their contract was based on a limited grant of power to those who govern. And now remember that, because it's very critical. And this isn't just some stuff that was going back in 1789. It's going on right now in our country, dealing with Article 2, the powers of the President under the War Powers Act. And we got a struggle going on right now between the Congress and the President as to what powers were given to which branch. But why were our founders worried about you also? Can you do things bad as a majority? Yeah. I mean, I was just watching Ken Burns' show on the war last night, and they had a segment on the internment of the American Japanese. We basically sent them to concentration camps just because of their ethnic origin. And this is what Alexander Hamilton wrote about in Federalist 78. He says, and he's talking about the courts and our role in the system. He said the courts of justice are to be considered as the bulwarks of a limited constitution. So back in 1787, he's already talking about this limited constitution against legislative encroachment. So he is worried about the Congress. Could substitute their judicial, you could substitute their executive encroachments. That the independent spirit of judges must be essential to faithfully perform so arduous a duty. And then he goes on, and this is really, is that judicial independence is equally requisite to guard the Constitution and the rights of individuals from the effect of these ill humors. That's what he's talking about, how you can, as a majority, you can be discriminatory against African Americans. You can be discriminatory based on gender. I mean, women didn't get the right to vote until the early 20th century. So these are ill humors that sometimes disseminate among the people themselves. And so now how do we guarantee that those who are governing us are not prone to these ill humors? Yeah, you write down rights. Actually, this is kind of interesting. You know the Bill of Rights? That didn't get passed until 17 And some of the authors of the Constitution said, this Constitution is a grant of limited power. It stands for itself. We don't need to write down rights because it's well understood. Others said, I'm not so sure here. I don't know what's going to happen in the future. We better put some rights down. And quite frankly, I think we're lucky that they did put those rights down because it's the Fourth Amendment. I always hit the mic. When I'm on a TV show, they don't hit the mic. And I just mess it. But I did that. I speak with my hand. Sorry about that. It's going to happen. Is that they said, put those rights down that we reserve to ourselves. So like the Fourth Amendment, search and seizure, right to freedom of religion, freedom of speech. So they put them down. So that is, but there's something else in the main body of the Constitution itself that they did. Okay. In the history of the state of Minnesota, I was the 78th person appointed to the Minnesota Supreme Court. We're going to celebrate 150 years next year. I got to be good. I got to be really good. I got to be darn. No, I'm not even going to say darn near perfect. I have to be perfect. Everybody agree with that? Everybody agree with that? What? Who disagrees with that? Who doesn't think I'm perfect? Stand up. You know, it's over 3 hours driving down here. Get up early, coming down. Is that then I have to endure a fire alarm and everything else. And then I have one of your students tell me I'm not perfect. Well, I'm going to give you a chance to explain. In front of all these, why did you say I'm not perfect? No one's perfect. Well, but I went through this process to get selected as a justice, and I've been re-elected twice. That doesn't cut it. No? How many agree with her? Is she right that I'm not perfect? But, yes. Oh, you are getting, you're just compounding it, you know. Is it, but, you're so right. And that's what our founders understood, is we're human, and we are fallible, and we are subject to corruption, and as Lord Atkins says, power corrupts, and absolute power corrupts absolutely. Well, I want you to come up here for a minute. I'm not going to let you off the hook, okay? Is that I found this very interesting. Is that she knows I'm a Supreme Court justice. She knows in 15 days all my colleagues are going to be down here. And is that I got to ask you a question, okay? When you told me that I was not perfect, in fact that I'm fallible, and in essence in that you said I'm flawed, right? Did you have any fear that I would throw you in jail? I mean, we have enough police officers around here. You probably call somebody. Did you have any fear I was going to take any actions against your family? None at all? This is interesting. Why didn't you have any fear?
Because the Constitution protects us.
Yeah. Now, remember I talked earlier about me and Bobby McGee and freedom is just another word, nothing left to lose, and I said how wrong it is. I cannot come up with a better definition of freedom than just said, I actually get chills up and down my spine. I have this young lady. And I mean, this is true. This is true because I believe so much in this document. Is that she said the Constitution would protect her against any repercussions that I may want to take. If I have any lesson that I want to leave you with after today is, lead your lives so that 20, 25 years from now, when your children are the same age as this young lady, they still have the same core belief that the Constitution protects them. And don't give up your freedoms. I mean, this is what it's all about. Anyway, now that I got you up here, I'm going to keep you up here. I want to talk about, I'm going to have you sit in that chair for a minute. I mean, I want you to let you know that the way you protect yourself against me is you divide power. And as Mr. Hagerly's here, he's all shown you this diagram, hasn't he? Didn't he show you this diagram in class? One right here. He's never shown you that one. You haven't got that appointment. Oh, he's off the hook. He's off the hook. Okay?
We're still on John Locke.
You're still on John Locke. That's how Jefferson would have divided power. Most all of it went to the legislative, a bit to the executive, and then it's only this big so you can read the J. Hamilton. Oops. He gave a little bit more power to the executive, a little less to the legislative, a little bit more to the judiciary. Today, this is how it's, we talk about the even division of it. And that's, I mean, if I go to the Supreme Court building in Washington, D.C., and they have that statue of John Marshall, remember, the fourth Supreme Court Justice of the Minnesota, or the United States Supreme Court. He established the power of the judiciary. And his power that he did is he gave us in the judiciary the power to interpret the contract. What does that mean, to interpret the contract? Yes. Right? Because this is a short document. It's only about 3,500 words. I mean, you know, it deals specifically with pornography on the internet, doesn't it? And it deals specifically with emails, doesn't it? Doesn't it deal about wiretapping? That's all in there, isn't it? No? Well, but it's in there in the Fourth Amendment. Talks about search and seizure. Talks about freedom of the press. So it is all in there, but we have to take that document and interpret it to circumstances. Now, I'm going to read, how much more time do I have? Pardon?
20 minutes.
20 minutes, okay, I got a little bit of time. Emily, I got to get your name. Emily, okay. Put this on. And this is my older robe, so you're going to be a little tricky. One of the sleeves is not as good as it should be. Here, put your arm right in there. And your last name, Emily? Shep Oyster? Judge Shep Oyster. I'm going to pull the chair back here a little bit. Emily is one of our judges. You may take a seat. Emily, I'm sorry. Yeah, you're right. You're female.
Yes.
Just notice that. We don't have women judges, do we?
Yeah.
We do? Somebody back there was saying, yeah, who was that? Okay, stand up. Ready? Do we have women judges?
Yeah.
Is that a good idea?
Yes.
Why?
Because women have like opinions too.
Women say, yeah, but wait a second. You know, when I was your age, I think there was one woman judge in the state of Minnesota. And it said, and we got along pretty well. In fact, there's a lot of people that are nostalgic for those old time days. Wasn't that a pretty good time?
Can you repeat that?
What? I'm that old, huh? I mean, but you say they have opinions, but, you know, we don't really need them on the bench, right?
Why not?
Well, no, I'm asking you the question. I get to ask the question. You're going to tell me why we should have them on the bench.
Well, otherwise it's discriminating.
Really?
If you didn't have like both female and male judges, would that be discriminating?
Okay, now I'm going to follow up on it. Do women think differently than men?
Yes. Sometimes.
Do they have different? Yeah, sometimes. That's a good answer. Do they have different experiences?
Yes.
Might they have different attitudes with respect to this domestic abuse and child abuse?
Kind of. Yeah.
Yeah, do you think those attitudes should be incorporated into judiciary?
Yes. Ethical.
How would you feel if you came to a court and you had 7 or 9 old men up there? Do you think they would understand?
Can you play football?
What? One of them played football. Yeah, I mean, would you feel that this system is open enough to all views?
Well, it depends on what the case would be.
Okay. Okay. Thank you. Your colleagues, your fellow students, they made a pretty good argument for you to be a judge. So, okay, I guess I didn't make a mistake. Actually, is that I have been in, you may take a seat, is that I've been in the judiciary as we've changed. And we've seen women come into the judiciary. We've seen minorities come into the judiciary. I will tell you something. It is a really, really important change. Because, right, women have different experiences as men. And they don't think differently all the time. In fact, some women judges can be as bad sometimes as men judges. Just because you're a woman judge doesn't mean you're a good judge. But you bring those different points of view. And that's really And so, now, Your Honor, are you a good sport?
Yes.
Okay. Well, we're going to give you a gavel if you're going to be a judge.
They're giving you.
No. You said you promised me you'll be a good sport. Okay. Oh, wait a second. It's Hagerly, isn't it? Stand up, sir. You laughed. And why did you laugh? You did. I mean, but she's a judge. She's a judge. And you laughed at her. Do you want to hold him in contempt? Well, you're gonna exclude him from your courtroom. You're gonna maybe give him a fine. But you know, Mr. Payne, I would expect more from a teacher. You know, really would. I said I expect that you might have done some study of European history, and you would have understood that someone wearing a wig like that, if they're in England, was probably one of the highest judges in England. But you know, judges should exercise compassion and mercy. You gonna let him stay? Give him a bit of a warning. Okay, but now you understand, sir, you don't laugh at the judge, right? Okay, very good. Oh, yeah, that's the right thing to do. Now, the thing I'm making a point is, 15 days from now, you're going to have the justices of the Minnesota Supreme Court on your stage. And they're going to come out in robes. You need to understand, we don't have the power of the budget. We don't have the power of the police. But what we do have is behind us. You are good, Emily. You're good. You're right. You're ahead of me on that. Is that we have the robe as a symbol of our authority. Now, I'm going to run out of time just because we're a little bit slow here. I got to do a case, okay? Sounds like I could start a joke, but this is true. A couple of police officers go into a bar. They look around and they see a number of people. Actually, it's the second bar they've gone into. They've gone in a bar called the Caboose, now they're in a bar called the Albatross. See a couple of young ladies sitting there. And they have two bottles on the table. There's the beer, and also this glass half full of a golden liquid. And seeing them drinking, and I go up to the young lady and said, "Would you show me your ID?" Now the officer is in full uniform, has a badge, American flag, whistle, Glasgow Billy Club, mace, even a taser, sidearm, and asks you to show the ID. Are you going to voluntarily show the ID? Probably. Oh, this is what happened too. She did show the ID. Officer looked at the ID, looked at the young lady, asked her address, and stumbled over her address, asked her how old she was. She said she was 20. The officer said, "Stand up." Okay, he just went. The officer went over to her friend. Friend panicked and said, "She's not 20, she's 23. And we're in trouble. Not big trouble, but pretty decent trouble. Okay, I have you sit over here. Now, you have to decide what you want to do after you finish school. Sit down. She wants to go to veterinary school. You know what's interesting about veterinary school? It's very competitive, okay? Sometimes harder to get into than medical school. And you are charged with 3 crimes. Consumption of alcohol as a minor, having a false ID, misdemeanors, $1,000 fine, 90 days in jail, and then a gross misdemeanor, showing a false ID to a police officer. With a gross misdemeanor on your record, what is your name, young lady? Maureen, I'm not sure you're going to get into veterinary school. You need a good lawyer. You want to pick somebody to be your lawyer? Choose wisely, because you need somebody who's going to be good. And by the way, the judge, if you can't afford a lawyer, the judge will appoint you. Because you can go to jail. Okay. Okay. decided it's gonna be low. Now, Mr. Hagerty, I need a minister of justice. Somebody who's going to represent the state, is going to protect our safety against scufflaws like this young lady over here. Okay. Oh, you did say you were going to volunteer. You didn't indicate you would be volunteering. Now, what we have here is our defendant charged with 3 crimes. And she talks to her attorney, and the first thing her attorney says is, I said, what's your name? Maureen, did you give your ID voluntarily to the police officer? You did. You did. Okay. Why? Why did you give it to the police officer? Did you feel intimidated? Did you feel you had no choice? Okay. Now, Ms. Chang, being the good attorney who says, you know, I remember back, Justice Anderson was at Marshall. He said the Constitution protects. And is in fact, is if the officers don't ask during for that ID, that's a good reason, right? That's cool. Search and seizure. That's what the Fourth Amendment is. We talked about that. It's not only is it implicitly in the Constitution, but it's explicitly in the Bill of Rights. Okay, so Mrs. Maureen, we're going to try to get that suppressed. And here we have our county attorney, the Minister of Justice. And believe me, he plays a very important role in our society because he sees that the law is enforced. But we also have an adversarial system. And so, Shane, stand up. You're going to go to our judge. You're going to stand in front of the judge at an omnibus hearing. You can stand where I am. I'm over here. Now, you paying attention, Your Honor?
Yeah.
And you're going to say is that, Your Honor, the Constitution means something down here in Lyon County. And in fact, this is that police officer has to have a good reason if he's going to deprive my client here of her rights. And is that what happened is police officer went over and stood in front of my client, and he did not have a whit of reasonable articulable suspicion that my client was underage. Okay? And so he shouldn't be able to, and he did. In order to get that ID, he seized her. He took away her freedom. We know that freedom is important there. One of your fellow students down there said, you know, we don't want to lose that. Okay. Good argument. It says, Your Honor, this isn't about the Constitution. This is about a young lady who's 20 years old, was sitting in a bar, was drinking, and she's underage. First of all, she's in a bar. She should expect police officers coming up and ask her questions. Shouldn't be afraid, right? Okay. And so she wasn't seized. But then, even if she was, the officer had good reasons. And so you call me. I'm the officer. You're going to call me and ask those questions. So you can ask me why, what I was doing that night. Well, I've been an officer in this town for over 20 years. You know, it's a college town, so we have a lot of young people, 18, 19, 20, 21. And a lot of them go to the bar. And I first went to the Caboose, and then I went to the Albatross. Now you're going to ask me what I saw. Well, I walked into the bar, and there were about 7, 8 people in there. Now you're going to get me a little more specific. You're going to get me to find a little bit more. So ask me to get a little more specific. Okay. Well, I would describe it as a younger crowd. And then you ask me what it means to be a younger crowd. Well, they look to be about 20, 21, 22. And then I went over to this young lady, just casually said, show me your ID. And she did. Game, set, match, right? Thank you. You have a chance to respond on behalf of your client. And you say, Your Honor, that's not enough. He didn't specifically identify as my client individually. It wasn't reasonable articulable suspicion individualized to my client. That's not a good enough reason to deprive her of freedom. Okay, so now, this is not the same issue you're going to see in the case that's coming here in a couple of weeks, but it deals with the same principles about the guarantees of freedom in the Constitution. And we have a judge here who has to make a decision. She's like a gatekeeper. And how she decides is going to determine whether that fake ID comes in. Because the ID was fake. It was her sister's. And her sister is 23, but Maureen is only 20. So, you have to answer two questions, Your Honor. And I will articulate them, and then you have to answer. One, would an ordinarily reasonable person like Maureen there feel seized under those circumstances? If she wasn't seized, our Minister of Justice prevails. She voluntarily gave the ID, it comes in, and she's kissing veterinary school goodbye. But if you say she was seized, that doesn't end it. Because you have to answer another question. Did the officer have a reasonable, articulable suspicion that was individualized? And if he did, in this case it was a she, was the officer, then he got the ID valid. But if he did not, then he seized her. So, are you ready, Your Honor?
Yeah.
First question, was she seized? Well, it was that she felt that she had no choice. So the officer put her in a position that she had no. She was seized. Okay. But did the officer have a good reason to ask for the ID? Yeah. Okay. You win. Okay. Thank you, Your Honor. You're done. How much time do I have? About 5 minutes?
About 4 minutes.
4 minutes. Okay. We gotta hurry. You gotta take off your robe, Your Honor. I need 3 volunteers. Okay. You can just put it back on the chair. One of the young ladies right there with your hand up way in the back, smiling. Yes, you. Yeah, you. No, no. No, it's the young lady. Yes, you. The one who's, no. You can come up to the young lady right next to you. Okay? Okay.
Told you. You said the young lady.
Yeah. Oh, yes, sir. You can come on down. Okay, the guy in the blue. Yeah, you stood up. You're come on down. Okay. Thank you. Okay. Now, Maureen is a little concerned. We're going to pull these chairs back just a little bit. Is that she wants to appeal. And in our court system, it's like a cake, okay? We have a district court. Our judge here was a district court judge. We have a court of appeals. Now, soon to be 19 judges, but they sit in 3-judge panels. Okay, Your Honors? You've heard the case, right? We're going to move this on a little bit because we're running out of time, okay? You know what the case is about? Question. Was she seized? Got to answer yes or no. And then, second question, if she was seized, you have to determine whether the officer had good reason. You just go back over behind there and deliberate because the attorneys have made their arguments to you, and then you can come back, make your decision, okay? Just all 3 of you. And you don't have to be unanimous. Yes, that's exactly. See, that's what happens with the Court of Appeals. They hear the argument, and then they go back and consult. Now, I'm going to have you move your chairs a little bit to the side. And it's because we're a little short of time, I'm hustling a little bit. But Mr. Hagerly, would you pick 7 volunteers to come down for me? So we can get this.
Marco, yeah, you're welcome. Blank. That's 6. Dylan.
See, the top court here is our court. This is the court you're going to see. There's 7 justices. I think one of our justices, for some reason, is not going to be here, but you maybe have 6, but Virginia has 7. And I just want to give this example is that it goes to the Court of Appeals. Maureen had an absolute right to appeal to the Court of Appeals, have them decide. She doesn't have an absolute right to appeal to the Minnesota Supreme Court, except for the type of case that we have here in 2 weeks. It's first-degree murder. All first-degree murder cases come to us directly. They bypass the Court of Appeals. That's part of the way it's structured in our system. And now, we're going to anticipate, because we're short of time, is that how many of you folks would want to hear this case? Raise your hand. 7. They voted they're going to take the case. They don't have to take the case. You have to have at least 3 votes on the Supreme Court if you're going to take the case. Now, you know what the issues are, right? The questions. We're going to hear what the Court of Appeals has to say, and then I'm going to ask you folks to go out and decide for yourselves on this issue. How you doing? How'd you put it like that? So you made a decision? Okay, why don't you come forward? See, what would happen is the Court of Appeals would have heard arguments from the attorneys on both sides. You can come forward. You can stand in front of the Supreme Court if you do. And they would have heard these arguments, and they would deliberate it. You can face the public, because you have. Okay, you made a decision. Are you unanimous?
Yeah.
You are. Okay. First question: was she seized? Okay. Second question: did the officer have reasonable, articulable suspicion to ask her for ID? No. No. Oh, right, that's pretty good. You just won. Okay, you can take your seat. But they reversed you. What? Yeah, I mean, it's kind of tough, isn't it? I mean, here you did your best, right? You did your best, okay? And they reversed you. Okay, so now you are going to feel. And you got divided, Court of Appeals goes one way, reverses justices. But, yeah, that's right. You won that. Excuse me. You're ticked right now. Because you won down below. And she's a scuffball. You know that. And you want to make sure that we get some law developed so we get an example, right? And the court has already said that they're going to take the case. So you have the 7 justices here. And again, you have to ask, what, about 2 minutes? Okay. You know what the questions are. Was she seized? Not just subjectively, would an ordinary person in Marine's circumstance, when an officer comes over and asks her for ID, feel seized? That's the first question. And if you answer that, no, it's done. Because she gave it up voluntarily. But if you conclude if she was seized, then you have to decide whether, in fact, the officer had good reason. Remember what he said. Younger crowd, 6 to 7 people. They looked to be 20, 21, 22. So go back and take about 30 seconds. And this is what happens. You will see this, is that when we're down here, we will hear the oral arguments, but we won't make the decision right away. We will go back to St. Paul. We will deliberate. One of us will be assigned to write the case. We'll circulate that opinion in 60 days. If there's a dissent will have 30 days to respond. It goes back and forth, and then we will issue the opinion. And I need 30 seconds. You don't have to be unanimous. First question. No? Okay. Okay, we have one that's right here. Anything else? Pardon? Okay, now, if you conclude that she's seized, the officer has good reason to ask her to. Okay, so things again, okay? How about the girls? Okay, good answer. Come on up. Here's where we have a slightly divided panel. How many of you believe she was seized? Okay. It's 6 to 1. Actually, that's the way the Minnesota Supreme Court ruled in this case. But they did so under the Minnesota Constitution. Because if they were to do it under the U.S. Constitution, you probably would be in the majority on the U.S. Supreme Court. And that's an interesting concept that we're dealing with. We have 2 constitutions in this state. Federal Constitution, Minnesota Constitution. Minnesota Constitution can't limit your rights more than the national Constitution. But it can give you more How many on the other side? Think the officer had a good reason? Got two. The reason I picked this case is because it is really a close case. And just that our court said that the officer didn't have a good reason. And probably the reason we did that because the officer said they looked to be 20, 21, or 22. What can you do at 21 and 22? If the officer had probably been a bit more specific, he probably would have had a good reason. She would have had a good reason to seize. And so we had a 5-2 divided opinion. Because these issues are tough and they're close. And they're interpreting that contract. And they're taking that general language from that contract, applying it to the real life situation of our defendant over here, Moran. Ladies and gentlemen, that's what we do. We interpret that contract, and that's what we're going